Yes. Because you have changed your glasses.
लगाए ही glasses हैं, change नहीं किया. Good evening, friends. And before we start the session, first of all, as they say, happy Karwa Chauth to everyone. I was just asking Mr. P.S. Rajagopal before going live to the session that does the festivity of Karwa Chauth being celebrated in Bangalore? He said it is, but since it's a cosmopolitan city. But be that as it may, all over the world, we have seen that this festival has taken his festivity to its best. Trikram and Beyond Law CLC have been taking different sessions on different spectrums of law. And then this endeavor, one particular part which we have not been doing it in other respects, but with Mr. P.S. Rajagopal, a senior advocate, Karnataka High Court, we have agreed upon to create a virtual book that is Understanding of Service Law. And then that endeavor, today is part 9. And this particular part will be divided further into 2 parts, where we will understand the vertical reservation as well as the horizontal reservation. Today's concept basically revolves upon the concept of reservation, concession, and affirmative action. Before we go, request Mr. P.S. Rajagopal, I will ask Mr. Trivikram to share his insights. Mr. Rajagopal will take over.
Thank you very much, Mr. Vikas Chatrat. It had been a very long time since we had a senior on the board. I am elated and I am so happy to see Sir on our forum again. Sir, once again, all our audience, your fan following, they are just waiting to listen to your erudite lecture. So once again, sir, on behalf of Beyond Law and CLC and on my personal behalf, sir, I extend a very warm welcome. Over to you, sir.
Thank you, Trivikram, and thank you, Vikas. Yes, I start with the note that for quite some time I could not address any session on service law. But I can assure you I was not dormant. I was doing some work on service law. Then I was writing, incidentally, chapter on reservations when I got call from Vikas. Reservation के बारे में कुछ कह दो. Then I told, reservation is a very vast subject. Firstly, we have to understand what is reservation and what is not reservation. And there is a large amount of misunderstanding in distinguishing between concessions or relaxations. And when I talk of concessions, it includes relaxations and weightages. Therefore, before I go into the different forms that reservation can take and what are the constitutional limitations on reservation, let me clarify as to what is not reservation. So in this context, we had to divide the whole subject into 3 chapters. One is general concept of reservation. What is reservation? What is only a concession or a weightage? And what is affirmative action? Then go into the details on the mechanics of reservation. That is how this session has been brought about. Friends, the foundational concept of our Constitution is equality. We find equality enshrined in Article 14, which speaks of equality before law. But it does not stop there. It says equality before law and equal protection of laws. Protection has two aspects. One is a passive protection. When somebody's rights are attacked in a very discriminatory or arbitrary manner, Article 14 acts as a shield to protect him from invasion of his rights. That is equal protection of laws. Equal protection of laws goes beyond a formal shielding of his rights. Equal protection of laws, in my humble view, involves enablement also, because let us take a heavyweight champion. The protection he needs is minimal, but a weak person, I'm not speaking in physical terms only, it could be economical, it could be in the matter of access to education, it may be in the matter of access to public employment. In all these, weaker sections require a dynamic approach of the Article 14 to see that equal protection of laws means first, he should be able to access the remedial fora, and then to enable that, certain what I could say, a protective discrimination, or what some authors have called as reverse discrimination, is permissible under Article 14. Then we have Article 16(1), which says equality in the matter of public employment. The concept of equality over a period of time has undergone a vast change. Some time ago, while I was speaking on contract of public employment and the concept of master and servant relation, I had an occasion to refer to judgment in Brojanath Ganguly versus Central Inland Water Transport Corporation. It is actually in the Supreme Court, it is titled as Central Inland Water Transport Corporation. And the exposition of contract law in that by Lordship Justice Madan, when he says contract between parties having unequal bargaining power is opposed to public policy. And while quoting the example of the unequal bargaining power between the employer and employee, he compared the situation in the matter of making service contracts between the might of the employer and weakness of the employee, saying that when we speak of equality in making of service contracts, it is comparable to equality between lamb and the lion. Therefore, lamb requires certain protections, and these protective discriminations we find in a plethora of articles in the Constitution. Let me say some of them. Articles 14, 15(1), 15(2), 19(1), 16, 16(1), 16(2), 19, which grants 6 fundamental freedoms, and 29(2). These are the clauses of the Constitution which speak of equality. Then there are enabling provisions to make the classes of people who are unequal by raising their access to education, their access to public employment by means of special provisions. What are these special provisions? Article 15(3), it enables the state to make special provisions for women and children. Then we have 15(4), which enables the state to make any special provision for the advancement of any socially and economically backward classes of citizens or for the scheduled castes and scheduled tribes. Then we have 15.5. This is very important. 15.5 came about when, in the matter of higher education, the Parliament wanted a better access to higher education for persons belonging to backward classes, scheduled castes, and scheduled tribes. That is, 15.5 enables the state from making any special provision by law for advancement of any socially and educationally backward classes of citizens or for scheduled castes or scheduled tribes in the matter of admission to educational institutions. Article 15.5 was approved by the Supreme Court in Ashok Kumar Thakur. Then when it comes to public employment, for example, one discrimination prohibited under 15.2 and 16.2 is that discrimination on the sole basis of sex, descent, origin, place of birth. Then to overcome that, Article 16.3 is there, which enables the Parliament to make special provisions in the matter of employment, stipulating requirement as to residence in a particular state or part of the state. Now, the series of special provisions for various backward areas we find in Article 371 to 371J, or now perhaps K also, are traceable to the power conferred by the Parliament, by the Constitution on the Parliament under Article 16.3. Then we have 16.4, 16.4A and 16.4B, which enables reservation in favor of scheduled castes and scheduled tribes and other backward classes. The phrase used there is backward class of citizens, within which it definitely includes scheduled castes and scheduled tribes. Then recently we have the insertion made into the Constitution of 16.6, that is providing reservation for people who are not covered by 16.4 or 16.4 or that is the class is economically weaker sections. Now, how do you justify the provisions for reservations? Is it a concession, or is it making an exception to Article 16.1, or is it based on certain more fundamental concepts? Initially, the view of the Supreme Court was that reservation under Article 16.4 is an exception to equality clause in 16.1. But later the view changed. The view had to change because of two things. One is preamble to the Constitution. Second is directive principles of state policy. Earlier view was that directive principle of state policy cannot be enforced through a court of law. Subsequently, a view developed that Part 4 of the Constitution, which deals with directive principles of state policy, is as much an integral part of the charter to achieve the goals set before the Republic under the preamble to the Constitution. And in certain cases, there may be occasions when the court can direct the executive to give effect to the directive principles, of course, subject to economic capacity, financial capacity of the state. Now, the driving force behind this concept of reservation is the preamble to the Constitution, which speaks of the people of India having solemnly resolved to establish sovereign socialist secular democratic republic and to secure to all citizens what the Constitution has aims to secure to all citizens. First is justice, social, economic, and political. And third, liberty. For a moment, let me skip that. Justice, social, economic, and political. And then equality of status and of, this is most important, and of opportunity. It is the foundational aim of the Constitution to secure equality of opportunity to every class of society. Now, when we speak of equality, it is not equality, a wooden equality or a static equality or what we call formal equality. The concept of equality underwent a thorough change commencing from judgment of the Supreme Court in N.M. Thomas. Then over a period of time, it evolved, and today, equality does not mean a static equality or a formal equality. Today's Act emphasis is on substantial equality. After all, it is said, all men are born equal. But fact of it is that some are born less equal, some are born more equal. This concept of, I do not call it as genetical inequality, historical inequality, which has come about due to over a period of centuries, due to various social factors which have contributed to the economical factors. These will have to be removed when we speak of equality. Therefore, it is not equality, not only means a formal equality, but we are moving the concept of equality from formal equality to substantial equality. It is this concept of substantial equality on the basis of which the concept of reservation, weightages, concessions, etc. will have to be tested. If we want to learn more about what is the difference between a formal equality and substantial equality, I would invite my audience to go through the judgment in Neil Erilo News, that is OBC reservation case 2022 4 SCC 1. In that, Lordship Justice Chandrachud has traced the evolution of substantial equality concept and judicially building up that concept into the Constitution or reading that concept into the Constitution by a comprehensive and a holistic meaning to the equality clauses and then the enabling clauses in the Constitution which provide for reservation concessions, etc. Anyway, that is it is a matter on which enormous study is required, and to have a clear idea as to how the reservations and weightages are justifiable, the judgment in OBC reservation case makes a very interesting and worthwhile reading. Now, I commenced saying that we have to understand the difference between reservation and concessions. Before I go to that aspect, let me clear one persistent one persisting wrong notion about reservation. When I go around any city these days, I find hoardings all over the cities, sometimes even written on public walls. Reservation is our birthright. And those who oppose reservation, they are anti-nationals. Let me make it clear that there is no compulsion under the Constitution to make reservation. All provisions, let us starting from Article 15.3 up to Article 16.6, 15.3, 15.4, 15.5, 15.6, 16.3, 16.4, 16.4a, 16.4b, and 16.6. If you read each of these articles, all that these articles say is nothing in this article shall prevent the state from making any provision. What it says is that either Articles 15.1 and 15.2, which speak of non-discrimination on the basis of religion, etc., or place of birth, or generally about equality, or Articles 16.1, 16.2, and 16.3. They do not, what is contained in those articles which speak of equality will not come in the way of the state to make special provision either under 15.4 or under 15.3 or under 15.5 or 16.4, 16.4a, 16.4b, and 16.6. Therefore, there is no compulsion on the state to make reservation or to grant concessions or to grant weightages. These are left to the executive policy to be framed by the state and the legislature, and courts cannot issue a mandamus or courts cannot give a positive direction to the executive or to the legislature to provide for or to implement reservation to a particular extent or in a particular manner. Of course, when reservation is provided by the executive, the job of the court is only test the validity of that reservation on the anvil of Article 14, which does not prohibit classification, but only insists on a reasonable classification. And then Article 335, which speaks that any provision for reservation in favor of scheduled castes and scheduled tribes, here I pause and say that it would include any other reservation also, shall be made when it is made or when it is considered to be made, it will have to keep in mind the consistently with the maintenance of efficiency of administration. These tests would be applied by the court, but court cannot direct either making of reservation or providing for reservations or in a particular manner or to a particular extent. Therefore, the principle is that constitutional provisions regarding reservation are enabling provisions, and court cannot direct either making of the reservation or much less making of reservation to a particular extent or in a particular manner. Reference in this regard may be made to Suresh Chand Gautam versus State of Uttar Pradesh, because this came about in a situation where M. Nagaraj spoke of collecting quantifiable data, etc. And then before that, Indra Sahni giving out the philosophy behind the reservation. In Gautam Chand, in Suresh Gautam Chand, Suresh Chand Gautam, the question before the Supreme Court was, a writ was filed in a making a very innocuous prayer. What was the prayer? Nagaraj has directed the collection of quantifiable data, and therefore let the Supreme Court direct the state to collect quantifiable data to satisfy itself about inadequacy of representation and then take remedial action. Supreme Court said, on an analysis of the prayer, what the petitioner is seeking is that he wants a mandamus to the state to take preparatory study to introduce reservation in promotions, and then based on that study, proceed further. It amounts to issuing a mandamus to provide for reservation, which this court is not authorized by the Constitution to issue. Therefore, these prayers are very common. In fact, my colleagues also had this problem. People come and say, sir, in Karnataka state, Article 16(6) has not been implemented. That is providing reservation in public employment for economically weaker sections. And they also say it is because of a particular caste bias. Which caste it is not relevant for us. Generally, the prayer, the grievance placed before the advocate is, sir, Constitution has provided for reservation, but state is not implementing. Therefore, file a writ petition. I've been telling, look, like Article 16(4), 16(6) is also an enabling provision. Court cannot direct that you exercise your power to do a particular thing and introduce reservation. Therefore, court cannot direct reservation to be made. Court can only test the validity of any reservation made by the state. Then, of course, there is next, logically, I should proceed to what are the types of reservation, or whether all reservations are one and the same. Broadly, the reservations can be classified into two classes. One is called social reservation or vertical reservation that we find in Article 16(4) and now in Article 16(6) also. These are vertical reservations. Then there are various other types of reservations. What are those reservations? Persons with disabilities or differently abled persons. Then women, rural candidates. Then we have project displaced persons. That is, earlier I used to laugh at this concept of reservation for project displaced persons, because under the Land Acquisition Act, when land is acquired for implementation of irrigation project or whatever project it is, compensation is paid to the land losers. Therefore, in addition to compensation, why reservation in jobs? Of course, that doubt, whether founded or unfounded, it is irrelevant now, because under the Right to Fair Compensation Act, rehabilitation package is one of the essential requirements. That rehabilitation package can contain providing employment to the members of the families of land losers. That also comes under horizontal reservation. Then we have reservation for ex-servicemen or ex-military personnel. Then in some states, there may be some reservations which are that state specific in the sense. There may be cases which are peculiar to a particular state which has given to this type of reservations. These are called as horizontal reservations or interlocking reservations. About the different types of reservation, this much only is necessary to be told now. Rest of the things I would be saying when I speak of what is meant by vertical reservation, how it operates, how the horizontal reservation operates. But I can tell you how these two types of reservations are different in their operation. If you, those of you who have not read, kindly read Saurav Yadav's judgment. Saurav Yadav, it is a 3-judge bench judgment where all the earlier judgments regarding working of horizontal reservation and vertical reservations have been considered, and a somewhat clear guidelines have been laid down in working of these two reservations. It would be helpful to you not only when we go into the mechanics of vertical reservation and horizontal reservation, even otherwise also, to understand the difference between the concept of horizontal reservation and vertical. Now, let me straight away come to what is not reservation, because that is the priority of my today's interaction with you. Now, for example, even without reservation, there can be a concession. You are aware that above the lowest category of class 1 posts, all over the country without exception, in the matter of promotions, there is no reservation, or reservation stops at lowest category of group A posts. There can, even in such cases, be some concession, though there may not be reservation. For example, if this question arose before the Supreme Court, in the matter of reservation in the cadre of officers, promotion from lowest cadre of officers to higher cadre in the banking industry. Originally, we had one thing to be remembered is that promotion from within the cadre of officers, from junior management grade up to top executive grade, they are all merit-based promotions. There is no, it is not by senior, it is merit-based. So the Government of India issued directives to all these banks, which they are obliged to follow under Section 7 of the Nationalization Act, that in the matter of promotion from one cadre of officers to another cadre, a concession be extended to members of scheduled castes and scheduled tribes. What is that concession? Concession is, if an officer belonging to these classes, SA or ST, falls within the zone of consideration according to his seniority, and if he is not found unfit for promotion, he shall be granted promotion. Now, there are two aspects. One is for selection posts, we are aware normally 1:4 is the zone of consideration. That is, if there is one post, 4 persons according to seniority are to be considered. Therefore, if there is one post and a member of the scheduled tribe or scheduled caste falls within that top 4 in the senior, of course, if there is only one post available, there can be no reservation. Therefore, let me give a better example. 5 posts, 20 people are there, and in the top 5 of the seniority list, he should be in the zone of consideration. Then his rank in the seniority should be within the number of vacancies. A person is there, belongs to scheduled caste, scheduled tribe. He must be in the top 5. Then second requirement he has to meet to get the benefit of this concession is he should not be unfit for promotion. This is a merit cum seniority promotion. Therefore, comparative merit is the criteria for promotion. But the concession given to the member of the scheduled caste or scheduled tribe is that he need not be most meritorious on comparative merit. He should not be unfit for promotion. What is this being unfit for promotion? If a benchmark merit has been stipulated for promotion, he should meet that. That is, if a person is within the number of vacancies and falls within the zone of consideration, and if he is unfit for promotion, he should be promoted. This is the concession. This came for consideration before the Supreme Court. First in Syndicate Bank's case. There, due to a wrong submission made on behalf of the bank, it was held to be a reservation. Subsequently, a review was filed, review was allowed. Then, after the judgment in Indrasani, 1997, another OM came, which only said that earlier reservation will continue. That was sought to be misinterpreted, saying that earlier it was only a concession, now it has become a reservation. Therefore, it has to be treated as a reservation. In Central Bank of India case, that is 2015 12 SCC 308, all these official memoranda were analyzed and interpreted by the Supreme Court. And Supreme Court said that what is available under these OMs is only a concession and it is not a reservation. Then we have, in the matter of admission to postgraduate and super specialty courses in the medical sciences. Now, almost every state in the country has a certain percentage of seats earmarked for in-service candidates. That is, generally, admission to these courses is based on merit secured in whatever examination conducted by the Government of India through its medical council, or earlier it was called as some entrance examination. Whatever entrance examination is there, earlier the entrance examinations were being conducted at the state level also. That is PG entrance test. Now it is centralized. It is based on merit secured in the PG entrance examination. But departing from that, certain percentage of seats are earmarked for doctors who are in government service or those working in government controlled, those who are working in the government service or government controlled organizations. That is called as in-service quota. The validity of that in-service quota is not to be tested on the anvil of reservation, nor mechanics of reservation like roster and all would apply for that type of earmarking of seats, which the Supreme Court said merely because in the rule it is mentioned as 25% seats are reserved for scheduled caste for in-service candidates, you cannot treat it as a reservation. It is only providing a separate channel for the in-service candidates. What is a separate channel? Separate channel is testing their merit vis-a-vis other in-service candidates who want to secure admission. It is treated as a separate channel, not as a reservation. Then a question came about quota rule provided in the method of recruitment, whether it amounts to reservation. Because the precise argument that was advanced was the in R.K. Sabharwal, while dealing with reservations for Article 16.4, the Supreme Court has initiated replacement theory. Therefore, even the recruitment operation of the quota under recruitment rule also should conform to the replacement theory propounded in R.K. Sabharwal. This question again came from incidentally from state of Punjab, because R.K. Sabharwal came from state of Punjab. Then this R.N. Bhatnagar, Dr. R.N. Bhatnagar also came from state of Punjab. There the argument was in respect of promotion to the cadre of professors. There was more than one chance. The argument advanced was was that quota rule means you have to apply R.K. Sabharwal. The Supreme Court said recruitment pertains to Article 16.1. Reservation emanates from Article 16.4. The principles of replacement theory that is propounded by the Supreme Court in R.K. Sabharwal would not apply to recruitment, which is part of Article 16.1. And Supreme Court said that quota provided under the method of recruitment in a recruitment rule is not to be operated as operation of reservation under Article 16.4. Quota provided under recruitment rule is not a reservation, but it is another mode of entry. For example, into service, there can be several modes of entries. Direct recruitment is a mode of entry. Promotion is a mode of entry. Deputation may be a mode of entry, depending upon the requirement of the stipulations of that service rule. These are different modes of entries, and these cannot be reservations. Then we come to the weightages. Now, what are these weightages? Normally, we come across the weightages in our day-to-day operation of service law, where certain irregular appointments have been made and a direct recruitment notification is issued. Persons who are already holding the office in the state irregularly, they are also eligible to compete. Then Supreme Court says, or the courts normally, we cannot grant regularization because direct recruitment is the best method. However, you can give a weightage for the years of service they have spent in government service, though on irregular basis. That is one type of weightage. Then what is the relaxation? Relaxation is, we find in most of these service rules, invariably I can say, age relaxation is provided for different categories of persons. Say, persons who are in service, there are rules which say when you are applying for a direct recruitment to a higher post as an in-service candidate, you are eligible for a certain relaxation in age. Then it is restricted to 4 years or 5 years or 10 years, as the case may be, subject to the number of years of service you have put. That is one type of. Then there is a concession. For example, in academic standards, even the UGC regulations provide that while a general candidate has to secure, ought to have secured 55% of marks in the postgraduate examination in the relevant subject. For scheduled caste and scheduled tribe candidates, it need be only 50%. General candidates 55%, reserved candidates 50%. Then there are certain concessions, like for example, a blind candidate availing the reservation under the reservation for differently abled persons. He is given the concession or he is given the benefit of having a scribe. Then there are certain categories of disabled persons who are given additional time in writing the written competitive examination. That is, if a general candidate is entitled for 3 hours, they may be given half an hour concession, half an hour extension. There are several such concessions. For example, in the application fee, there are cases where for general candidates, application fee will be 500. For reserved candidates, it may be 250. For ex-servicemen, relaxation in age is granted. All these fall under the category of concessions or weightages. These will have to be tested. Validity of these will have to be tested on the annual of Article 14. That is, whether if it is justified, it is justified. Whether the classification is a reasonable classification. Remember, all the concessions and weightages that concessions, except the weightage for service, all other concessions I cited, they do not compromise the testing of merit. Now, suppose by age relaxation or fee concession, a person is allowed to apply and write the written test. These concessions do not have the effect of impairing the testing of merit, because merit is tested after a person becomes a candidate, irrespective of the class of the candidate. They have to write the same written examination. They have to face the same interview, and merit will be tested on the same standards for all these people. To put it differently, level playing field in the matter of determination of merit will not be disturbed. And such concessions have been held to be valid by the Supreme Court in, say, for example, I'll just tell one case where this type of concessions have been considered at length. That is, after Bhatnagar, there is one. Observation. This similar. This there is one. No, Sunandar is different. I'll come back. There is another case. I'll come back to that. I'll give the citation before I go. But then there is particular weightage called rural weightage. This has been tried. First, it was tried in Andhra Pradesh. Thereafter, it was tried in Rajasthan. Then it was tried in Karnataka. That is, providing weightage of marks for persons hailing from rural areas or who have studied in rural areas. The very interesting reservation that was made in favor of students from those who have come from rural area. The leading judgment on that is Kailash Chandra Sharma's case, which arose in state of Rajasthan. Can you see what they did in state of Rajasthan, which attracted the wrath of Supreme Court? In recruitment to the posts of school teachers, certain marks were provided for educational qualifications. Then certain bonus marks were provided for domiciles. Domiciles of Rajasthan, 10 marks. Residents of district in respect of which or posts in which recruitment is being made, 10 marks. Then residents of rural areas of district, 5 marks. The Supreme Court said that classification as rural and non-rural candidates is not based on valid criteria because it proceeds on the basis that, on a presumption that all rural candidates are backward. It cannot be. You cannot say that merely because a person is from a rural area, he is backward, and therefore he is entitled for the benefit of either weightage or reservation. It also said another thing. Under Article 16(3), if any law has to be made stipulating residence or domicile in a particular area as a qualification for appointment, it can be done only by the parliament and not by the state legislature. Then the third is, look at the category of post to which application is being made. It is of a school teacher. Normally, who becomes a school teacher? Qualification required is matriculation, or maybe some teacher's training, or maybe a graduate in any faculty, and then B.Ed. These are normally the candidates will be lower income group or lower strata of the middle income. The access to access to most modern educational institutions is not available to vast majority in our urban areas also. It is not a characteristic of rural area only. Then it also said that classification as a person who has studied in rural area or domiciled in rural area, and those not in the rural area, it has no nexus to be sought to a nexus with the objective that is sought to be achieved, that is recruiting the best candidates to become teachers. On all these grounds, the rural weightage was struck down in Kailash Chandra Sharma's case. That is, in fact, 2 judgments were rendered in respect of the Rajasthan rural weightage on the same day by the Supreme Court. Both are reported in the same volume of SCC, that is 2002, 6 SCC. These 2 judgments, Kailash Chandra Sharma and another, there is one judgment. Both of them cover the question as to what are the requirements that have to be fulfilled to treat a rural area candidate as belonging to a class, and if that proper classification is not made, how it can be bad. I was telling about the concessions and their validity. The judgment is Jitendra Kumar Singh versus State of UP, 2010, 3 SCC 119. Then I would conclude today's today's interaction or now my talk by referring to one judgment regarding the weightage of marks which were found for with the in Andhra Pradesh for recruitment to services to state. The total marks that was stipulated for the maximum mark for which the written examination was conducted was 800. A rule was made providing for 5% additional weightage to the candidates from rural area. That means, in addition to what he secures in the written examination, he would get 40 weightage marks merely for the reason that he is from a rural area. That was struck down by the Supreme Court in V. Sunanda Reddy's case, saying that the object of recruitment is to make selection of candidates on the basis of merit. Merit is compromised by adding 40 additional marks to the marks secured in the written examination. Therefore, it will be violative of Article 14 and 16. Of course, several reasons were also given. Similarly, Karnataka state also adopted ventured into making rural weightage, that was struck down. Then to cover up the defect pointed out, namely absence of correction of data to say that all rural candidates are economically backward or they belong to social and economically backward classes. No data has been placed. To overcome that, one Justice Ramakrishna Commission was appointed. On the basis of that report, they gave this rural reservation. And it was challenged in the Supreme Court did not entertain the writ petition, or it issued notice thereafter that it transferred the matter to Karnataka State Administrative Tribunal. And what happened in Karnataka State Administrative Tribunal is hilarious tragedy. Tragedy in the sense, it did not test the validity of the rule. Hilarious in the sense, the remedy suggested by the tribunal and accepted by the state government was give appointment to all the applicants also who have challenged the rural reservation. This flies in the face of the law stipulated with the Supreme Court, which said that when a recruitment rule is challenged, you cannot dispose it of this way. You have to test the validity of the rule. And now that is being banded up by some of the persons in Bangalore as rural weightage, rural reservation has been upheld, and therefore no question can be raised. Anyway, on some day, I hope that it would be tested. And my personal view is that that reservation is totally bad. But people have become used to it. Nobody has questioned it. At some time, it may be questioned, or as it happens most of the time, wrong laws may remain on the statute book, unhampered by values of law, because nobody challenged it. Thank you. And I have today tried to say what is not reservation. Of course, I have only told a few things about what is reservation. I think when I deal with vertical reservation, the horizontal reservation, we'll have scope to consider all that. Trivikram and Vikas, now over to you to questions. I think I have, as usual, and my overdrawing the time, you have permitted me, and therefore you have made me a recalcitrant teacher or speaker who always violates the rule.
As usual, the session was so engrossing, despite the fact that it's a vast topic to cover up in the short period of around 1 hour. It's a very difficult task. And they say, I was doing one of the sessions, Justice Sikri said, Justice A.K. Sikri, that the most difficult is that if you have to make the shortest speech, and that is in one of the sessions also said, that if you have to speak 1 hour, it can go at any stage. For 15 minutes, it has to be more crispy. But if it has to be 5 minutes, it has to be the crispiest. So that's the way we learn from Mr. Rajagopal, who I would always say that he's Raja of the knowledge, and we always learn from him. So one of the our full bench from Punjab Haryana High Court, there's one Abhishek Rishi. There also there was 5 marks being granted for the purposes of rural people. That was struck down on the same anvil of Kailash Sharma. And then we had one judgment wherein the guest teachers who had a backdoor entry, they were being granted 1 marks for the selection process. It was held to be bad on the anvil that you are ensuring that they are being appointed. What could not be done directly, it was being allowed to be done indirectly. Let me check out. It seems that you have spoken so well. One of the principals, Mr. Mohan Bhalla, said, wonderful discourse on reservation with utmost conceptual clarity and resounding knowledge of judicial precedents. I think there couldn't be a better way to close today's session, and we will continue with the other parts on the vertical and horizontal reservation. And thank you, sir, for sharing your knowledge despite busy schedule.